So, Mr. Coughlin, you indicated that it was Rule 12 of the Justice Court rules?
Yes, Your Honor, but I believe it's actually Rule 13 or 14. I'm looking at it now.
Go ahead, sir. What is it?
Yes, sir, Your Honor.
Rule 13.
Rule 13, Your Honor. Just one second. Rule 13 of the Justice Court Rules of Civil Procedure, Your Honor, in the state of Nevada speaks to counterclaims and cross-claims. It allows me to state either a compulsory or permissive counterclaim to the extent that the claims made arise out of the transaction or occurrence that is the subject matter of the claim, the opposing party's claim here, which is dealing with an eviction. They do arise out of the same, in that while Counsel Baker states rent is not at issue here, the retaliatory eviction defense that I cite does bring into play all those issues. And with that come in all the failure to cure and the subsequent rent deductions that are allowed under the statute in benefit of the tenant, myself. May I be heard, Your Honor?
Yes, and can you address Rule 81 too?
I don't have a copy of Rule 81 in front of me, Your Honor.
Well, Rule 81 says these rules do not govern procedure and practice in any special statutory proceeding insofar as they are inconsistent or in conflict with the procedure and practice provided by the applicable statute.
Yes, Your Honor, I think that hits the nail right on the head. This is a summary proceeding provided by statute, NRS 40.254 and NRS 40.253 sub 6. The only issue here today is possession of the property. The court's inquiry is very focused, and it is only as to whether there is a legal defense to the alleged unlawful detainer. If Mr. Coughlin has claims against third parties or my client, he can make them in a separate civil suit. What are these third parties going to add to the discussion of possession of the property today? None. There's been no complaint filed.
Well, I don't know if the third party complaints are, but the issue of retaliatory eviction may or may not.
Well, Your Honor, under NRS 118A.510, the burden is on Mr. Coughlin to show retaliation. He's not done that. He's not offered any proof that there is any sort of retaliation here. The parties, the whole purpose of the 30-day notice in the statute and in the lease is freedom of contract, Your Honor. Once Mr. Coughlin is a month-to-month tenant, the landlord is free to terminate the lease with 30 days notice. Mr. Coughlin is free to move out with 30 days notice. If we flip it around and Mr. Coughlin had given 30 days notice and we had come down here and tried to stop him from moving, that just doesn't make any sense, Your Honor. There's been no proof put forward that there is any retaliation here.
Well, actually, I have no proof so far that the lease is over or anything else. I don't even have a copy of the lease.
Your Honor, the statute provides that I am to provide that today, and I have copies here.
Your Honor, Rule 109 speaks to a 20-day period of notice prior to a hearing, which I believe is applicable in this case, and has not been provided.
I'm sorry, I didn't catch any of that.
He said
Rule 109, Your Honor, setting of trial and actions. NRS 118A.510 speaks to retaliatory conduct by the landlord against tenant, and goes into the extent to which notice is required and the opportunity to put on a defense and to litigate those claims is afforded to litigants, and certainly turning off their power in the middle of the 5-day notice period is unduly burdensome, and it, I believe, is in violation of the federal statutes and state statutes respecting the appropriate notice one must give to tenants prior to shutting down power.
Your Honor, I have a copy of the lease here. Would you like this, sir?
Yes, please.
And I attached that to my-
The section you're citing to, sir, applies in which we have, where we're not going under summary eviction. And this is a summary eviction.
I thought you said at the outset that this was a no cause and not a summary eviction, Your Honor. Or Mr. Baker said that.
No cause is summary. Non-payment is summary as well.
No cause is summary as well, even though it gives 30 days versus the 5 days that the non-payment gives.
You're talking about two separate notices. They gave you 30-day notice, all right? They give you a 30-day notice of termination of lease, and that's the no cause. Then, when you don't move out, then it's an unlawful detainer, which is the 5-day notice.
And that's, you're saying a summary in nature, Your Honor.
Yes.
And to that, I filed a tenant's answer and third-party, or a counterclaim bringing in third parties.
Well, first of all, as to the third-party complaint, I am going to rule, as I indicated earlier, that there is a specific statutory procedure in this case, which is applicable under Chapter 40 of the NRS. And therefore, you're governed by that statutory procedure, which does not allow for counterclaims to be heard at the same time. You can file a separate independent action as indicated by counsel for the
NRS
plaintiff.
40, you say, Your Honor, does not allow for third.
Chapter 40, in a summary proceeding such as this, does not allow for counterclaims to be filed in the same action. You have to file a separate action.
Chapter
And that's under Rule 81 of the Justice Court Rules of Civil Procedure.
Is it, okay, Your Honor, in addition to Rule 83, Your Honor, I don't believe any of those rules allow a landlord to turn the power off in the middle of a 5-day unlawful.
I'm not saying they do, sir.
I'm just,
I will allow you to testify as to what happened and why you believe the summary eviction should not be applicable in this case. And if you establish a case to my satisfaction, then I will set it over for trial. All right? But at this point, you haven't done that.
yes, sir, Your Honor.
You've come in to argue a motion to dismiss based on failure to comply with notice and other issues, which I've denied at this point. So you can sit down if you want to testify as to why this should not be a summary eviction. I will permit you to do so.
Yes, Your Honor. Even were this to go forward as a summary eviction, Your Honor, I would just like to state for the record, I'm moving for a continuance based upon the unduly prejudicial nature of the shutting off the electricity in the middle of 5 days.
Well, you were here quite some time ago and knew all about this, so that's denied. You first came in here to court back when this court dismissed the prior case, in case number 1492, trying to find the date at which
I believe it was the 26th, Your Honor, of September, for hearing. Approximately.
That was the 27th, Your Honor. I remember because that was my birthday.
Right. In any event, that's been more than 20 days. And I know on that date you were fully aware of what was happening because the plaintiff tried to proceed at that time, which I denied. They attempted to proceed on this case as well. All right? Or do you not remember that, sir?
I remember the hearing, Your Honor. I would think there's something that when a tenant alleges a retaliatory eviction, that the summary and extremely quick nature of this process is slowed down somewhat.
Only if the court finds that it's a meritorious defense, which I haven't done, sir. I haven't even been presented any evidence to persuade me that you have any meritorious defense whatsoever.
Yes, Your Honor.
And I'm giving you that opportunity to proceed. So do you want to proceed or not?
Yes, sir, Your Honor. I have an abundance of evidence in support.
Well, come up here and take the stand, sir.
Yes, sir, Your Honor. May I bring my laptop with me? Because
Well,
it has pictures that I intended to offer in a videotape as well.
Wait a second, sir. No, you may not. What I'm asking you for is to establish a prima facie case of retaliatory eviction through your testimony. And then if I determine you've established a prima facie case, then we'll set it over for trial.
Yes, sir, Your Honor.
So if you want to come up here. Go ahead, sir.
Yes, sir, Your Honor. I believe a prima facie case has been established with respect to the claims of retaliatory eviction and been supported by the various exhibits that have been attached to both my original tenant's answer and my subsequent tenant's answer and this most recent motion for continuance specifically.
I have that.
Specifically, Your Honor, what's convenient here is this has all pretty much been detailed in emails to and from the landlord and myself. Further, I took videotapes of an incident where a good deal of property damage was done to my home law office.
Done by whom?
The landlord's agents. And if you reference the lease, I believe it's subsection 28, the lease specifically provides that any damage done to the tenant or his property by the landlord or the landlord's agents would result in the landlord being held liable for such damage. I can testify as to the damage done. I have a videotape showing the landscaping crew doing the damage. The third-party defendants were involved in that to some extent. The landlord admitted in writing that he authorized the third-party defendant's Green Action Lawn Services conduct in that regard. Aside from the property damage with respect to the landscaping incident, a prima facie case can be established.
Sir, how was that retaliatory? What were they retaliating for?
I believe he's evicting me, Your Honor, based in part on a number of factors. That's one, because I complained about it. Two is
Because you complained about the lawn service?
the conduct of Green Action Lawn Service, yes. They caused what I believe is at least $1,000 damage. In addition, the landlord failed to cure a number of habitability issues that were brought to light in writing, and he was given 14 days. The statute allows a deduction from the rent. The landlord agreed in writing to these deductions.
Well, you have deducted 3 months' rent.
That's a factual matter, Your Honor, that I believe is in dispute. And
So you're saying you've paid the rent? Do you have evidence of payment of the rent today, sir?
payment in the sense that rent deductions agreed to in writing and work done incident thereto amounts to a payment of the rent. In addition to...
Okay, well, do you have evidence of that?
Yes, sir, Your Honor. The stairs, Mr. Merliss, the stairs to the law office were crumbling. They were presenting a hazard and an aesthetically displeasing appearance. Mr. Merliss agreed to a rent deduction. The stairs were repaired. He was submitted a statement in that regard. He subsequently filed or caused to be filed notices that ignored that rent deduction, ignored the rent deduction he agreed to in writing and the attached
Okay,
emails.
well, sir, I need to know precisely, first of all, how much is your rent per month?
$900 a month.
How much was the bill for the stairs?
$1,250.
Anything else offsets that you're claiming today?
Yes, sir, Your Honor. The landlord agreed to a $350 offset for taking care of the weeds at the house. I offered to...
So how much was that, 300?
He agreed to $350 for that season, and he failed to respond to a request for the prior season. So I believe I can argue $700.
Well, okay. But you said he agreed to 350.
Yes, sir, Your Honor.
Okay. Well, I don't think you can argue beyond what he agreed to.
Well, Your Honor, he never responded to a previous season's request in that regard after 14 days' notice, and I believe NRS 118A allows for a rent deduction.
But habitability, what does the weeds a year ago have to do with habitability?
The weeds were extreme, Your Honor. They created a noxious weed ordinance hazard.
Okay, wait a second. Whose responsibility is under the lease to maintain the
I believe
landscape?
it's the landlord, Your Honor.
Do you have citation to the lease?
Yes, sir, Your Honor, and I'll cite to that, but even absent that, his subsequent conduct ratifies an interpretation that would deem the landlord responsible for. And I believe the noxious weed ordinance in effect in Reno specifies that it's the property owner's responsibility. But the lease does speak to that, Your Honor. My attachments, and there's a good deal of photographic evidence attached as exhibit, I believe it's 3 to the motion for continuance. Exhibit 2. It shows, brings up the issue of the mold and the insulation. All of these issues are in writing attached to the original September tenant's answer, wherein approximately 30 pages of emails between myself, the tenant, and the landlord, Merliss, prove that he was provided 14 days written notice of various habitability issues, including mold growing on insulation that had fallen from the ceiling and hit a dirt ground that lacked a vapor layer. There's pictures. I know the printouts there are not that clear. I do have high quality color photographs on my laptop. just another small matter, Your Honor. There was a matter of $125 reduction that was agreed to for the disposal. All these deductions, the landlord, Merliss, has subsequently seemed to have forgotten.
Okay, wait a second. You have weeds, the total you're claiming is 700. And now you say there's 125 for what?
A broken kitchen garbage disposal.
Which you repaired,
Yes, sir, Your Honor.
and you have receipts for all this?
I've submitted statements to opposing counsel.
All right, so if I understand this correctly, you owe $2,700 in rent.
Your Honor, opposing counsel said rent's not at issue here.
Well,
so-
you're making it an issue. You're the one who said that I'm supposed to look at this because this is in retaliation for your complaints, right?
To the extent that an eviction's being sought, yes, Your Honor, but the issue of whether or not I owe any rent, I believe, has been conceded at this point.
Conceded how?
Or not even alleged by opposing
No,
counsel.
what they did is they dismissed the action for non-payment of rent. So they're not evicting you based on non-payment of rent. That doesn't mean, and you were talking about a counterclaim today, which you wanted me to address, for retaliatory eviction. And I'm trying to find out what the retaliation was for. You're saying it has nothing to do with rent, then that's fine. What is the retaliation about?
Subject to NRS 118.8.510, the retaliation applies because it occurred after written notice by the tenant to the landlord of both items, both matters in statute, such as noxious weed ordinance, as well as complaining about habitability issues. And
Retaliation is for complaining about noxious weeds?
noxious weeds, property damage done by the landscaping crew, and failure to cure habitability issues on the landlord's part after 14 days written notice had passed.
Okay, so you have noxious weeds, landscaper damages, and what was the third?
All these various please fix it landlord types written notices.
Well, that's not habitability. I mean, habitability is specifically defined by statute. So specifically, what was the habitability issue? Lack of heat? What?
Your Honor, I believe the insulation matter with its attendant mold problems, it comes within the essential services. I've seen some authority that seems to suggest insulation is an essential service. There's safety issues with regard to
Insulation is an essential service.
or at least I believe so in some jurisdictions, or at least it speaks to habitability. Insulation does. There's a window that's remained broken and with exposed shards of glass still held in by the caulk in the window that presents a hazard. The stairs, the crumbling stair risers. My mailman has complained about that. To the extent it looks bad, it's not that safe. The wood deck to the front entryway seems rotted out.
And these were not pre-existing conditions when you moved in?
No, sir.
So all this happened since you've lived there?
Yes.
Stairs rotted out?
The concrete stairs, they were patched up in a manner that seemed to suggest that they were done by an amateur. When I moved in, they subsequently, the patches failed. So, it seemed like every day another rock would be crumbling. You could sweep them away. The riser is the part your toe would kick. not step on. And when those are crumbling, they just keep crumbling. It's just like pulling a thread out of a sweater. So no, they were not pre-existing.
So what you're saying is because you complained about these four things, the landlord went ahead to evict you,
Yes, sir, Your Honor.
and it had nothing to do with the non-payment of rent.
I believe it had to do with invoking the statutory right to deduct rent.
So, okay, so prior to your exercising your statutory right to deduct rent, and you determined that this eviction, the first eviction, let's put it, because I think you claimed retaliatory eviction based on the first eviction, did you not?
Yes, sir.
So, the retaliatory eviction was based on these things and not your failure to pay rent.
Yes, sir, Your Honor, including the complaining of the property damage by the third-party agents of the landlord, his employees, or agents.
Right. Cross-examinations.
Your Honor, I'm happy to cross-examine, or I'm happy to simply present argument.
All right. Anything else, sir?
No, sir, Your Honor.
Okay, you can step down. All right, landlord, you can make any argument.
Thank you, Your Honor. Let's just start with the statutes, Your Honor. If I understood Mr. Coughlin's testimony, his contention is that the no-cause eviction is in retaliation for his complaints to the landlord about habitability. I think that's what he testified to, and he named a couple things: weeds, landscaper damage, insulation, windows. NRS 118A.290 provides what habitability is. Mr. Coughlin, he must show, among other things, Your Honor, that the property substantially lacks one of these enumerated items: effective waterproofing, plumbing facilities, a water supply, electrical lighting, outlets, etc. There's been no testimony or any proof that the property substantially lacks any of those things. With respect to the weeds, Your Honor, paragraph 22 of the lease: tenant will irrigate and maintain any surrounding grounds, including lawns and shrubbery, if they are for the tenant's exclusive use. This is a fenced-in corner lot. They are for the tenant's exclusive use. He's supposed to maintain the weeds. He didn't do it. Dr. Merliss paid somebody to come in and fix them. That's not a habitability issue, and it's not even addressed.
I'm sorry, I'm confused now.
Yes, sir.
You said he shall maintain what? The weeds?
Tenant will irrigate and maintain any surrounding grounds,
No, I understood that.
including lawns and shrubbery, if they are for the tenant's exclusive
So
use.
you're saying the tenant is responsible for maintaining landscaping?
Yes. Yes, Your Honor. That's paragraph 22 of the lease. At any rate,
Have we put the lease in evidence yet?
well, I believe I brought a copy, Your Honor. I would offer it into evidence. Mr. Coughlin also attached it to his motion for continuance. I would offer it into evidence now, Your Honor.
All right, well, hang on one second, because I
have another copy here, Your Honor. It's been misplaced.
the documents filed in this case do not have the lease, but it may be.
I believe Mr. Coughlin attached a copy to his motion for continuance filed last night.
In the last hearing.
No, last night, sir.
It was filed, I believe, Monday or Tuesday.
Well, I'm not sure I have that motion.
Your Honor, you might have handed that to me when I was on the stand.
All right. I do have it. I apologize.
I'll just quickly interject, Your Honor.
Well, you can wait, and then when he's done, you can interject, but so paragraph 22,
Yes, sir. Fifth line down, sir. Sentence starts at the end of that line with the word tenant. It's probably a bad copy, but
all right. I do see that.
Your Honor, just moving forward with the other items identified by Mr. Kaufman. Insulation, windows, garbage disposals.
Well, the other question I had about the weeds, he says he had them done for $350, and there was some agreement he would get a credit. You indicated that the landlord actually had the weeds
Your Honor,
taken down.
yes. My understanding is the only rent deduction ever agreed to by the landlord was $350. I believe it was for June, could have been for May, for Mr. Kaufman to deal with the weeds. That was not disputed, and in fact, Your Honor, if we go back to the last case, the quantification of the rent in our 5-day no pay notice gives credit for that. The court gave credit for it in the in its minute order. Dr. Merliss also paid landscapers to. Dr. Merliss also owns a property next door. The landscapers were doing the weeds next door. There were still weeds in Mr. Coughlin's property, as I understand it. He didn't take care of the weeds, so the landscapers also pulled the weeds over there. That's my understanding. It has nothing to do with this proceeding. Mr. Coughlin's third-party claims, as he calls them, have something to do with the landscapers pulling carpet out of his front yard or something.
Well, there were no third-party claims filed, so
I understand.
they're not even at issue.
I understand, sir. I'm trying to shed a little light on the weed situation. There was a credit. That is the only credit. Mr. Coughlin's not shown any other agreed-upon credit. And what's interesting here, Your Honor, is that, on the one hand, Mr. Coughlin is arguing that the landlord agreed to all these rent deductions, and then on the other hand, he's saying that, well, because I'm claiming rent deductions, he's evicting me in retaliation. It doesn't make any sense, Your Honor. Which is it? And he's not presented any proof of either. Under NRS 118A.510, Your Honor, Mr. Coughlin has the burden to prove that the eviction was in retaliation for one of these enumerated things. He's hanging his hat on habitability, but the lease puts the duty on Mr. Coughlin to maintain the property. Every time he's got a broken blinds or a broken window that, how did the inside pane get broken? We don't know. Mr. Coughlin won't let us inspect. He's claiming that's a habitability issue.
Well, I do have a question. The court previously ruled that he needed to deposit the rent, which he disputed, but what's your position with respect to the requirement to deposit rent when you're alleging habitability?
Your Honor, I think the court got it exactly right last time, requiring Mr. Coughlin to deposit the rent into an escrow account. That's what the rules and the statutes, I believe, provide. In this case, though, Your Honor, the only issue is possession based on a no-cause termination of the lease. Mr. Coughlin owes rent, but we're not here to seek rent today. If there's going to be claims for rent, that's a separate civil action. It is not a summary proceeding.
It's unduly prejudicial for Mr. Baker to be able to interject all these accusations and then run and cry wolf when it comes time to support them. As he's done in his pleadings, his style in his pleadings is to say, opposing party concedes this point when nothing of the sort was done. He says, Mr. Coughlin outright lies in his pleadings. He's making this allegation about a licensed member of the Nevada Bar, and he provides an
Well,
absolute...
sir, he didn't say that just now, so I no overrule the objection, but is there anything else?
Your Honor, Mr. Coughlin's burden to show retaliation is under NRS 118.8510. He has the burden to show that my client acted in retaliation. He's not done that. He's not pointed to any specific piece of evidence that would show that. In order to hang his hat on the habitability, he has to fall under some category in NRS 118.8.290. He's not shown that. He's not shown that the property substantially lacks anything. He's shown that he had an issue with some weeds or an issue with the broken window. And let me just say this, Your Honor. At the last hearing, I had here Mr. Randy Fisher, who is a local handyman. I had with him as a witness a gentleman from A1 Electric. We sent those people out to Mr. Coughlin's
Your Honor,
property.
objection here, sir.
I'll sustain that objection.
Your Honor, I can offer documents, invoices, and authenticate them myself because I received them from Mr. Fisher.
Well, I don't think there'll be any need to do that at this point.
Okay.
Anything else, Mr.?
Your Honor, only that we have tried to inspect and Mr. Coughlin has not allowed us to. Therefore, he's not allowed to proceed under the habitability statute.
All right, sir.
Mr. Your Honor, if I may at this time provide some further support, such as I referenced my intention to earlier with regard to showing high-quality photographs elucidating some of these habitability issues with regard to certainly having some of these pictures of mold are kind of disturbing. I don't think anybody in this courtroom would want to live in that situation. There's not
Well,
just one
obviously you
ordinance.
do want to live there because you're fighting the termination.
Your Honor, I wouldn't want to live there with that mold stain where it was. I submitted notice in writing. Not only 14 days passed, but a good deal of time passed. $500 was spent in eradicating the mold issue. With respect to the habitability
Who spent
issues-
$500?
I'm sorry, Your Honor?
Who spent
I
$500?
did, Your Honor. I submitted a statement to Mr. Baker. Your Honor, the broken window comes within the purview of section .290 of NRS 118A. In addition to the noxious weed ordinance that the city of Reno has, comes within the language in section 290 speaking to a violation of a applicable housing code or a complaint thereof.
Well, sir, how do you get around the lease, sir? The lease requires you to maintain the lawn.
That's Mr. Baker's interpretation of the lease, Your
Well,
Honor. The
tell
lease
me
does
what
not
your
say
interpretation-
weeds. It does not say weeds. It says lawn. There's no lawn. It's dirt. In that regard, I got high quality, high density green woolen carpet to make the appearance of a sort of faux grass installation. A good deal of money and time was spent so that I could have a law office that didn't have a dirt lawn. Mr. Merliss, a neurologist who's chosen to spend upwards of apparently $5,000 to litigate this rather than fix a window and stand behind the rent deductions, and who didn't show up today, who didn't stand up in court, when you yourself, Your Honor, told him to raise his right hand and stand to be sworn, and who has clearly indicated a lack of respect for this process. He's indicated a habit of kind of shifting tasks, which he seems to find minor and tedious, onto people whose responsibility it isn't to do those tasks. He is essentially trying to make me his pro bono property manager. He says, go get two estimates for that little problem you alerted me to and then deduct them. I'm out of the country right now in Thailand or somewhere. Well, I mean, that's something landlords do. That I'm an attorney. That's going to take me an hour or two. Can I bill you $225 for that, Dr. Merliss? No, I can't. I'm just doing that for free for you. Oh, you seem to employ this time-honored landlord tactic of ignoring tenants' written complaints and hoping to win by a war of attrition, or just make them feel like they're being tedious and high maintenance. When a clear review of the 30-some-odd pages shows that I've been extremely conscientious throughout the year and a half that I rented from Dr. Merliss, to the extent that I've endured disgusting conditions in this place in efforts to save Dr. Merliss money. Just a
All right, sir, here's the deal. I think I've heard enough.
Can I show the pictures though?
I've looked at them. I see the mold.
You can't see the mold in those
Well,
reproductions.
all right, bring up any other pictures you got, but what you said is you corrected that. You spent $500 to do that.
Yes, sir, Your Honor. May I approach?
You may.
And counsel was provided a CD of these pictures in addition to photographic
Bring it
reproduction.
up.
Sorry, Your Honor. May I just quickly...
You're going to have to hand it to me because I can't see it in the light
I'll
of
do
it.
a slideshow, Your Honor, if that'll be all right, real quick. And there is a short video wherein the issues of the property damage are essentially admitted by the Green Action Law.
I'm going to object to any video of any anything. It has no relevance to possession of the property today. And I've never seen it.
You were provided a copy of it, counsel.
Well, I'm going to look at your pictures, not the video, sir.
Okay, Your Honor. Okay, Your Honor.
I do have a question, Mr. Baker. The rent was last paid when?
Your Honor, I'd have to check. My recollection is May, but I don't know. Again, we're not seeking rent today.
No, I understand you're not, but I believe it is integral to the defense of habitability, how much rent is owed.
I'm not sure I make the connection, sir, but
Well, because I believe he needs to deposit the rent less any amount that he's entitled to credit for.
yes, sir. I agree with you.
You can go to the next picture right in that, or I can get some slideshows in.
Where's the arrows?
Yes, sir, Your Honor. I believe it's the... Is that moving the pictures?
There's no, yes.
Okay.
I believe June 1 the rent was due, sir.
So it's 5 months.
June, July, August, September, October, and I believe there should be a credit for $350.
For the amounts my co-tenant paid?
No, for what he's saying is undisputed is the weeds.
I
There
believe
was
he's
a
referring
one-time
to
credit,
an amount Melissa Ulloa paid to the landlord for June, Your Honor.
We can make it
And this goes to
$500.
the Rule 11 issues I'm speaking of, Your Honor. Can plaintiffs' attorneys blindly file motions against pro se's without doing reasonable investigation as to whether or not their claims are based in fact or law? Can they just churn and burn landlord-tenant claims through the courts, collect money for them without knowing whether or not
Sir,
it's professional to do so?
I'm happy to address the joint obligation of Mr. Coughlin and Ms. Ulloa under the lease, Your Honor.
Your Honor, the pictures of the carpet being left in the street and on the sidewalk, that's how Mr. Merliss's employees left the carpet. It was installed in a manicured manner. They came on. For some reason, he decided to pay both me and this crew of landscapers to do the same job. One wonders if he's so well off as a neurologist that he can afford to have the same job done twice, why he doesn't just accept my offer to have the window fixed for $150.
Objection relevance.
It's a hissy fit by an MD.
All right, sir. I'll give you one last chance to add anything else.
Yes, sir, Your Honor. I believe the retaliation argument, prima facie case has been made, specifically with regard to the habitability issues. Habitability includes safety. The crumbling stair risers clearly presented a situation where that was that issue. Habitability includes windows being broken. That was clearly supported in writing by the attached emails.
All right, sir. I am going to rule now because, first of all, I find under the NRS, if you want to make a habitability claim, you have to deposit the rent. And if it wasn't clear in my order previously, I'm going to make it very clear today.
Your Honor.
That now, sir, I'm going to give you credit for your alleged habitability issues. The rent that is due as of today would be $4,500. I'm going to give you credit for the stairs of $1,250, weeds of $350, weeds of $350 twice, the garbage disposal $125, and the window $150, which comes out to $22.25. In addition, wait a second. In addition, I'm going to give you $500 credit for the mold abatement, which is $27.25. So the $4,500 minus $22.25 is $22.75. I will continue this till tomorrow at 9 a.m. for you to deposit the well, it won't be tomorrow, it'll be Monday.
Your Honor, with respect
Sir.
to the $1,000 claim for damage to the landscaping installation, if you wouldn't mind.
I'm not going to give you anything for that. That has nothing to do with the landlord, so far as I'm concerned at this point. That's a third-party claim, which you can proceed against the third party.
Your Honor, the lease
That is not habitability, sir. It has
the
nothing
lease
to...
says that he's liable for damage done on my property.
Who said?
The lease says that, subsection
I,
20.
well,
Clearly.
not by third parties,
It
sir.
does, Your Honor. It says by his agents or employees, he is
Yeah,
responsible.
and I do not find that they're his agents. I find they're an independent contractor. And so if you deposit the rent by Monday at 9 o'clock with the court in the amount of $22.75, I will continue this for trial on the merits to determine whether or not there really is a habitability issue. If the rent is not deposited, then there will be no continuance. The eviction will be granted forthwith on Monday morning at 9 o'clock. And furthermore, the court is not making any finding other than that you have made an argument about habitability and that you are entitled to trial on that issue if you deposit the rent. All right? But you're not entitled to trial if you don't deposit the rent. And I've given you credit based on your allegation, which I do not find was substantiated today. I simply find that you made that allegation. that this is what you are owed. And so if you deposit the rent, then we will set this for trial, and it will be the following week after that, on the same court date, same day of the week.
Tuesdays and Thursdays. So, on a Tuesday, it would be at 10 a.m.
And what date is that?
Are you looking at, okay, he has until the 17th to post
Yeah,
the 2275, and you're saying have the hearing the following week, which
Yes.
would be the 25th of October.
okay, the 25th of October at what time?
That would be at 10 o'clock.
All right? So, that's the court's order, and we'll see you back then. You have a good day.